Good afternoon, everybody. I'm Trevor Emslie, and Peter Dachs is on the other side of the computer screen. Today is the 22nd of June, a day that always causes me to rejoice because the 21st is the shortest day in the Southern Hemisphere, and the night of the 21st is the longest night. And so from today, the days start getting longer. And even though it might get cold, at least the sun rises earlier, and that's always a comfort to those of us who live in a sunny country. Anyway, so that simply dates it. Our topic today is the pay now, argue later principle. Peter, do you want to say hello before we get into it?
Thanks, Trevor. Nice to see you again. And yeah, as you say, it'd be really nice to start getting some slightly longer days and shorter nights. Eh? So yeah, I'm looking forward to that.
Yeah. Right. So the pay now, argue later principle has been with us for some time, but I thought I would just mention a couple of cases. And the first one I'd like to mention was the Metcash case, which is a very long judgment. It's a judgment of the Constitutional Court. And Metcash tried to, in fact, in the court below found that the pay now, argue later principle was unconstitutional and violated certain provisions of the Constitution. And we could spend from now until next week discussing this case, and it's extremely long. But the court held that the pay now, argue later principle in the VAT Act, because it was VAT that was involved in the Metcash case, that it did pass constitutional muster. And some of the reason for that was that taxpayers could approach the court for interdictory relief, if so health. I've got the head note in front of me. Let me just read from one of the points. The principle of pay now, argue later was one which was adopted in many open and democratic societies, and in many of these jurisdictions as well. Some scheme for the immediate execution against the taxpayer was provided to ensure that the rule was efficacious, which suggested that it was accepted as reasonable in societies based on freedom, dignity, and equality, as required by Section 36 of the Constitution. Further, the effect of the pay now, argue later on the individual taxpayers was ameliorated by the discretionary power conferred on the Commissioner to suspend its operation. Even if Section 45 of the VAT Act therefore constituted a limitation on the right entrenched for Constitution, it was a limitation which was justified within the meaning of Section 36 of the Constitution. Accordingly, Section 36(1), 42A, and 45 of the Act did not ask the jurisdiction of the courts of law to the extent that it could be argued that Section 45 limited an aggrieved vendor's access to an ordinary court of law. Such limitation was justified under Section 36 of the Constitution. So, pay now, argue later principle was approved as passing constitutional muster by the Constitutional Court, and the attempt to have it set aside being unconstitutional failed. Then there's another case called Capstone and another versus SARS. It was in 2000, it was reported in 2011. It was a decision of the High Court, Mr. Justice Binns Ward. This was prior to the enactment of the Tax Administration Act. It was under the old Section 88 of the Income Tax Act. But the pay now, argue later principle in the Income Tax Act underwent a revision before the Tax Administration Act came in. And there were two taxpayers involved here. And in the one case, an application had been made under the old section, and the decision was then given negatively under the new provision. And in the second one, suspension had been granted under the old provision, but it was then revoked under the new provision. And again, Judge Binns Ward held that the new provision was really just the way he put it was expositionary of what the position was under the old provision. Just spelled out certain things more clearly, and even went so far as to say, well, that actually makes it easier for taxpayers to challenge a decision by SARS not to suspend. One interesting thing of this judgment, which puzzled me at the time, and still puzzles me somewhat, but can be used to the advantage of taxpayers if they're alive to the point, is that we criticize these provisions on the basis that the old Section 88 did not expressly enjoin the Commissioner to have regard to the merits of the appeal when determining a request for suspension of payment. Judge Burns Ward held that in fact it and it expressly referred to the merits of the appeal as a relevant consideration. And he said this followed from the provision in subsection 4, which authorized the Commissioner to refuse a request if he was satisfied that the appeal was frivolous or vexatious. So what he was saying is that when you consider whether something is frivolous or vexatious, you have to have regard to the merits of the appeal. Now, I must confess, maybe I'm just not up to speed on this, but I would have thought that that was a slightly different test. Whether something is frivolous or vexatious goes, I would have thought, to the bona fides of the request. The merits are a separate matter. So you might have a fully bona fide application, but the merits might be against you or the merits might be for you. Whether something's frivolous or vexatious, to me that suggests that you're not bona fide. So that to me there are differences of opinion, but certainly that reference to frivolous or vexatious is now in section 164 of the Tax Administration Act. And on the strength of this judgment of Judge Burns Ward in a capstone case, decision of the Cape Provincial Division, one can require SARS to have regard to the merits of the taxpayer's appeal on the findings of Judge Burns Ward. Peter, do you want to have something to say about section 164?
I think so. I mean, as you say, it's now, the case law has now been overtaken by statute. So the Tax Administration Act now deals with suspension of payment applications. And, you know, I always say, Trevor, it's your first big fight. You know, clients come after an assessment and they say, what's the next step? And they're thinking we're going to be talking about objection and heading off to tax court. And my point to them is always, your first fight is basically keeping your money, you know, arguing that you successfully apply for a suspension of payment application. And why? Because, you know, as you know, it can take 3 years, maybe 4 years to get to the tax court. So from your assessment, it can take 3 or 4 years to get to the tax court. And if you've paid up front, you know, a lot of clients say that alters the whole sort of dynamic of the dispute process. You know, you've paid across the money, and they often say, why would SARS then come to the settlement table? They've got your money. So I always sort of describe it as your first sort of big fight and your first big test. And I think one of the things that clients don't realize is the Pareto principle, but that your finalization of audit letter is an assessment. You'll have seen millions of those, but it's often just a long letter that sets out SARS's position on various aspects and rebuts certain comments that you may have made in earlier correspondence. But it says somewhere this letter is an assessment, and that often clients don't pick up on that. And once you get the assessment, you owe SARS money. In respect of dividends tax, I think it's payable immediately. In respect of income tax, it's payable on the payment date, which is the end of the next month. But still, there's a tax debt that is now due and owing to SARS. And clients often say, well, so what? You know, what are they going to do? There's a tax debt, but so what? What does that mean? And section 172, I think it is, of the Tax Administration Act says that SARS, on the back of an assessment, can go off to a court and they can make a statement to the court, and the court then, on the basis of that statement that becomes equivalent to a civil judgment for a liquid debt. And that's enforceable. They can go off to give it to the sheriff, and the sheriff can come knocking on your door. They have to give you 10 business days notice. Let's point that out. But you know, it has real teeth. And I think it's quite interesting in the context of, you often read in papers about tax revolts. It's going to be a tax revolt. We're not paying our tax. And I often think, you know, SARS have got, in the tax administration, they've got proper teeth. You know, they can issue an assessment, and then they can enforce the assessment through the Section 172 notice and come and collect. So it's not it gives a lot of sort of power. You know, there is the ability to apply for a suspension of payment, and that's Section 164 of the Tax Administration Act, and you know, we should chat about that a bit. And what that does, though, is from the minute that you submit your suspension of payment application to SARS, SARS can't proceed against you in relation to the tax debt until they've given you notice of how they've responded to your application. And it's 10 days after they've come back with their response that they can then enforce against that tax debt. So my advice to clients is always get your suspension of payment application in as soon as possible. And then the ball's in SARS's court, and they need to come back and give you a response. And it's only after they've given you a response, you've still got 10 days after which that tax debt becomes enforceable. And I don't know what your experience is, Trevor, on that, but you know, it's often, there's a lot of toing and froing, and it's often quite difficult to know when SARS has definitively come back in respect of a suspension of payment application, because it's quite a fluid process, I find.
Yeah, but the position is that until SARS have made their decision, whether it's favorable or unfavorable, and if it's unfavorable, you have 10 business days off, they can't take any steps against the taxpayer.
Exactly
I should mention an instance, and of course I won't mention anyone's names, but a taxpayer noticed that without any warning, a substantial amount of money had disappeared out of that taxpayer's account. It was an individual person.
Sure. And
then there were 5 years of assessment involved, and a suspension of the obligation to pay request had been made about a year beforehand. Nothing had been heard. And then suddenly letters were received after the money had disappeared, saying that we acknowledge receipt of your suspension request, dated such and such, and that date was the day before the letter declining it, although it had been submitted a year before. So I mean, there was a clear error. I mean, what it implies that SARS receives a request and then the following day gives the result. This was a year. It was clearly wrong. I mean, there was an error staring one in the face. And these things came, and they took the money out of the account, and
sure.
The taxpayer then had to threaten and not only threaten, but actually did bring an application in, because no decision had been made by SARS. And then when it was drawn to the attention of the right people, they were very apologetic, and they undertook to withdraw it, but didn't do so straight away, and were had to go to court and have it postponed. And then eventually the thing was withdrawn, and costs were tendered by SARS and all of that. But it was all, you know, quite nerve-wracking for the taxpayer concerned. And the upshot of it was that SARS has now granted the suspension request. So it's a satisfactory outcome for the taxpayer. But you know, it just seems like the left hand of SARS didn't know what the right hand was doing.
Yeah,
and how these things happen, I honestly don't know. I have no idea. So one has to be careful, has to take this possibility seriously. I agree with you. It should always, when, I can't remember if we did so at the objection stage or at the appeal stage. I think it was at the appeal stage. Put in a request for suspension at the same time.
And just on that, Trevor, because I find that those suspension of payment applications are handled by the debt management division at SARS. So, it goes to a slightly different department to the assessors, if you like, in my experience. And I find that quite often they come back with the offer of a partial suspension. So quite often we'll go in with our client and say, we ask for a full suspension and argue for a full suspension. And quite often SARS will come back and say, we'll grant you a partial suspension. That partial suspension is often around 50%. And you need to pay the 50% in installments. So that seems to be a fairly common sort of occurrence that we've seen in practice. And there's no basis for that 50% and the installments. So if you feel like you have a strong case for full suspension, then you can go and review, and we can talk later about what the review process is. But I think there is a fairly sort of standard practice that I've seen sort of develop in terms of a partial suspension, firstly, and secondly, payment in installments over a period of months. And that's, I think that's a practice more than following the process set out in Section 164, where Section 164.3 deals with the reasons for a taxpayer to apply for a suspension and the justification. And there are a whole lot of statutory factors that are quite interesting. We can go through a few of them. I think the first point is that they're not exclusive. So you can use additional points besides those in Section 164.3. I find the most interesting one is 164.3d, and that talks about whether the payment of the tax is going to result in irreparable hardship for the taxpayer, not justified by the prejudice to SARS or the fiscus if the tax is not paid. So it sort of implies a weighing up of interest between the taxpayer's interest and SARS's interest. And obviously the taxpayer can't argue SARS's case. We don't know what SARS needs the money for, but you can argue your own case and the taxpayer's case. And I think the important point is that irreparable hardship doesn't mean what some taxpayers mean, that I'm going to go bankrupt I pay it. Obviously, that's not the hardship. It's just that you won't be put in the same position as you were before paying the tax. So if you think about a taxpayer that's got illiquid assets, if it has to dispose of those assets, get cash, pay the cash to SARS, by the time it wins in court and gets the money back again, it either can't buy that asset or the price has moved. That's the kind of irreparable hardship that's relevant here. You can't be put back in the same position. It's very rare for clients to just have cash lying around. So often there is hardship, and often it is irreparable in the sense that they can't be put in the same position because they'll end up having to dispose of an asset. Even if it's a bank, for example, that ties up capital, or you could say a taxpayer could just go to a bank and borrow money, but that ties up lines to the bank that it could otherwise use for funding, working capital, expansion of its business, etc. So there often is quite a strong case, Trevor, I find, in respect to this irreparable hardship point. And as I say, it doesn't mean that you're going to go bankrupt if you make the payment to SARS. It's a much more lenient test than that. But I find that's a very sort of interesting one. What I haven't seen is SARS's counter to that, being, well, we need the money for X or Y, Z. And I suppose ultimately, if it came in front of a court, they'd have to weigh those two up against each other.
I'm just looking at Section 164 now, subsection 5. It says a senior SARS official may deny a request in terms of subsection 2, or revoke a decision to suspend payment in terms of subsection 3, with immediate effect if satisfied that A, after the lodging of the objection or appeal, the objection or appeal is frivolous or vexatious. That's that point about.
That's your point.
With regard to the merits.
Yeah, that's exactly right. I think one of the other things they look at is whether the disputed tax, the recovery of the disputed tax is going to be in jeopardy, or whether there's the risk of dissipation of assets. So they're looking at, is the taxpayer going to use the money to dissipate assets so that when SARS wins in court in 3 years' time, they can't collect against it. And I think there's a Carmel trading case, was an SCA case in 2008, talked about a dissipation order and what that meant. And that really meant a taxpayer kind of wasting or secreting assets so as to avoid a particular event, for example, in this case, the payment of tax. So that's something that the taxpayer needs to sort of overcome and say there obviously won't be any risk of the tax not being paid. So
you,
your best.
you and I don't act for dissipators of assets.
I was going to say that often doesn't come up in practice, which is a good thing. That's not something you want to be involved in. And then the security is quite interesting as well, Trevor, because that's a bit of a strategic one, because one of the questions is, has the taxpayer tendered security? Yeah. So the question is it necessary? Yeah, sometimes our clients say, well, they'll invite SARS to say, well, SARS, do you need security? And we invite you to discuss what security you need if you do, in fact, need security. And we can talk about how that's made. The taxpayers don't go in first up by tendering security. It's a question of like, what do you give SARS? What do they want? There's so many different ways of providing security. So I think that's more of a conversation, but you need to deal with it in your application.
Yeah, I mean, just the ones I've been involved in, very often this is used as a checklist of so, the first thing is whether the recovery of the disputed tax will be in jeopardy, whether there will be a risk of dissipation. A, B, the compliance history of the taxpayer with SARS. Again, you and I deal with taxpayers with exemplary compliance records. C, whether fraud is prima facie involved in the origin of the dispute. I mean, if fraud is involved, I think you can forget any request for
absolutely, yeah, absolutely.
And then there's the irreparable hardship point, and then security.
And as I said, those aren't exclusive. So if you've got other points to make, then you need to make them. And to bring in those points that you realize about it not being vexatious. The taxpayer really intends to defend. It's not just an exercise in futility. So I think bringing those points into the application are important. And if there is a possibility of a review, you obviously want your application for suspension to be as powerful and as detailed as possible. And I think with compliance history, it's often good for a taxpayer to actually put in a table and show your compliance history for as long as you've got it. Show that you've submitted your returns on time for X number of years, at least 3 years. Put that in. That goes in front of SARS, and they need to dispute it if in fact they can dispute it. So I think this suspension of payment application is a very important document and needs to be treated in that fashion.
Yeah, and I would think that in many instances, while preparing the request, one should have at the back of my mind a possible review application if the request is denied. Obviously it depends on the circumstance. And also what SARS says. If SARS says no, what are their reasons? They've got to give reasons for their decision. And but when it's not a case of one size fits all.
No, that's exactly the point, Trevor. It's taxpayer by taxpayer. It's not one size fits all. There's an interesting sort of counter argument, and I have heard this sort of said sometimes a little bit in jest, but some people say, especially some people work in the financial services industry, say, well, let's pay SARS, because if you pay SARS and you win, you get your money back plus interest of, I think it's currently 7%, which is a high rate, and you take no credit risk because you've got government risk. So what a great way to sort of make a deposit. But as I said, it's often tongue in cheek, because it's not your business. Your business is not a tax dispute, and it's not certain when it's going to go to court. As I say, it can take at least 3 years. It ties up your capital, and that's just not an efficient way to run a business. But it is interesting that, and it needs to be made that if you win in court, you get your money back and you get interest, which of course is taxable. Conversely,
I know of taxpayers who've been very unhappy with the way that SARS calculates the interest. And
that's interesting.
In fact, a bank said that, and I've even been involved in litigation where they go to court and saying that SARS has worked out the interest wrongly, and so I'd be careful of that attitude.
And the converse is, if you don't pay now and you end up losing in court in 3 years' time, then obviously you pay interest on that amount. So I mean, it cuts both ways. The rate's the same, and so but I've yet to meet a tax says, it's a really good idea for me to make payment up front And that's why it's quite a weird concept, the pay and argue later, because instead of contractual and intellectual disputes, you just don't have that. You keep your money until you lose in court. So it's kind of a weird concept that we've sort of got used to through our tax system, but it is a bit counterintuitive. And that's why I describe it as sort of the first fight, if you like, when you're in tax litigation. And I think just on the review, Trevor, maybe we're just touching on that as well, because as you said, it's if you submit your application for suspension and it's detailed and it's reasoned, and SARS comes back and says, no, I'm not going to suspend, or that maybe they give you suspension terms that aren't acceptable, then one needs to consider review. And review is obviously under Promotion of Administrative Justice Act. So there's been an administrative action, the Commission has decided something, or a senior SARS official has decided something. And if that decision is sort of inter alia irrational, then you can go under PAJA and have it reviewed. And I think that's becoming a bit more popular now. We've seen SARS being taken on review in various contexts recently. And I think reviews in relation to suspension of payments are also something that need to be considered depending on the circumstances.
Yeah. So, I don't think one can offer advice in a vacuum. Obviously one can't, but I think the one thing one can say is that when an assessment is received and there's a substantial amount involved, a request for suspension of payment should always be considered and taken very seriously at that early stage.
And as you say, to submit it in a detailed application, so that will help your review. If you send a detailed application for suspension and SARS comes back with a one-liner theoretically saying no, that obviously plays well in terms of your review prospects and in terms of the administrative action taken by SARS. And I think also in the review, what we've seen is that when you apply for a review of a suspension of payment, you then write to SARS and say, please agree not to collect the tax until pending the outcome of the review process, which can take a number of months. And SARS will either come back and say yes or no. If they say no, you can then apply for an interdicting SARS from collecting prior to the outcome of the review process. And we had a client that successfully interdicted SARS a couple of years ago on that basis in Pretoria. And the judge found very easily in favor of the taxpayer in those circumstances. Why wouldn't you interdict SARS? There's a review process going on, and the outcome will determine whether the suspension is correctly granted or not. So I think, as I say, that's becoming quite sort of common, these review processes.
Okay, well, may now argue later survives and we have to live with it, but we'll focus on the argue side.
That's very well put.
Yeah, Peter, thanks for the chat.
Nice chatting as always. And
And
we'll next time. Cheers.